Welcome to the Plant Grow REIT podcast.
Welcome back to the Plant Grow REIT podcast. Today we are going to be joined by one of our wonderful associate lawyers here at Aintree Group Legal, Liam McColl, who is going to be diving in a little bit deeper on a very topical issue in his world of disputes and litigation law, specifically around directors and office holders and their right to information about the company that they are representing or working in. There are plenty of cases out there, and Liam alludes to it, of cases where directors have requested information that they do inherently have a right to access, and the board or other directors have denied that access. And then if it has to go to court, there's a process that goes through because inherently those office holders do have a right to access that information, and there are very few instances where they shouldn't be granted that. So Liam goes into a little bit of the history of this area of law, what rights directors and office holders actually have, and the cases in which a board would be able to deny them access. And he also touches on what happens if you are a director but you want your agent, so your accountant or your lawyer, to be able to access that information, and just the process and how it goes through the court when those requests are disputed. So over to Liam.
Hi, welcome back to Plant Grow REIT. My name is Liam McColl. I'm a lawyer at Aintree Group Legal. I primarily work in litigation and dispute resolution. And today we're going to be talking about a topic that has been very topical in some of our work here at AGL, which is specifically to do with the director's right of access to company books and records. I think it's pretty important that a lot of directors or people who are company officers who work heavily in this area, and especially even accountants and people who are advisors, et cetera, are really across the law generally into what happens with directors' right to access books and company records, including financial records, because at one point coming up in that company's life or that person's tenure as a director or company officer, at some point there is going to be a request for access to company books and records, and they need to be completely across with what is expected of them and what they have to do and what their rights are. And that also includes people who are actual directors themselves, and they want to know what their rights are to the company books and records. So I'll try to be as simple as possible, but and I'll try to break it down as much as I can. But if it does get confusing, I apologise. I'm happy to take any questions on notice.
So firstly, what is a director's right of inspection?
A director's right of inspection or right to access company books and records is what they call a common law right. So it's something that is, it's as old as the hills, and it is, enshrined in the law of Australia, but also in, going all the way back to England and English law as well. And it was always the case that directors have a right to inspect the books and records of the company that they are a director of. And coming into 2001, we've got the Corporations Act, which is the major piece of legislation that governs basically the corporations and commercial rules in Australia. And it's a huge symposium of sections and words and definitions and rights and procedures that everyone who is ever worked in law will be very familiar with. And until 2001, it was predominantly a common law right, and then it was codified in statutory right. And it comes in the way of two particular sections, which is Section 198F, which is the director's right to access company books. Now, it's pretty broad because the word books is defined in Section 9 of the Act as a document, which is unhelpful, but that is also how law works. And so people often are saying, well, what is a document? And then you've got to go and do further research about interpretation to find out what that is. But helpfully, there's also another section, which is Section 290, which is the director's right of access to financial records. And financial records we can easily define as, receipts, financial records, and tax returns, and trial balances to do with the company, et cetera, et cetera. So the difference between the two sections is one is a little bit more broad, which has to do with just a document generally for whatever that might be. And then you've got 290, which deals with financial records. And of course, people are going to be more preoccupied with a financial record rather than just a random document for whatever purpose that it might be. So sort of tearing away ourselves from the Corporations Act just for a second, there's a couple of cases which I like to refer to particularly, and I won't go into them with any great citation because no one will really, hopefully not know what I'm talking about. But there's a case called Oswald and Barrup Holdings from 2011, and it goes into the common law generally and the statutory right and explains those sort of limitations and the access generally. And one of the things that it quotes another case, which is, again, gets a bit older and goes to talk about the common law right, which is Geneva Finance. Now, in Geneva Finance, which was 1992, Justice Owen, he confirms the right of a director to inspect books and records which relate to the affairs of the company is an incident of the office of the director and exists so the director may properly perform their duties as a director. And that carries in as well into a 2003 case judgment in Fox and Gadsden. And Justice Austin then says it even a little bit better, where he says directors cannot be expected to carry out their substantial responsibilities, including their fiduciary duties and their duties to attend to the solvency of the company and its general management, unless they can be sure of having full and unfettered access to documents of the company. And so what they're saying is, they've broken it down pretty simple even of itself, but how can you be expected to discharge your duties and your role as a director if you cannot see the records and the books of the company? So it is essentially the law is making it pretty simple that it's something that they should not be prevented from or hindered in their ability to discharge their duties, and they should be able to have access to the books and records and be able to inspect those. And it's a pretty broad power because the statutory right there is meant to reflect the common law right that already existed. The court's always going to presume that a director also intends to act in any way consistent with their duties and not to abuse the confidence reposed in him or her by using information for an improper purpose.
Does the director need a valid reason to gain access?
Director doesn't actually have to demonstrate a need to know or furnish reasons before exercising that right of access to the documents. They don't need to say, I need them for this reason or that reason, or I need to do that, and they need to justify or qualify themselves. They're the director and they have a right of access to those documents. Now, there could be a time when a director says, hey, I want access to these particular records. They could be financial reports of the company to do with a particular financial year. And the board could turn around, or their accountants or the company's lawyer, and say, no, I'm not giving you access to those books and records. And they might say for whatever reason. They might say, well, why do you need those? Well, the director doesn't have to turn around and say, well, these are the categories of reasons that I have, and I'm pretty sure I meet that threshold to say that I'm not using it for an improper purpose. The right in and of itself means that you should be able to have that right.
What would happen if a director's access was denied?
Well, a director has certain rights, and that's unfortunately going to the court because it's going to be an application that's going to cost you money, and you're going to be going to the court and saying, hello, Mr. Judge, sir, I would like an order granting me my rights that already existed, and I thought that the Corporations Act would be able to confer upon me to make sure that we wouldn't have to be in this position, but here we are. And so then the court will sort of examine all the reasons. The onus is not necessarily on the director itself to show why they want access to those books and records, but it may be, and it very well may be, that there is a question asked of them about, well, what is the purpose, to determine whether that is not an improper purpose. Because if there is an improper purpose to look at those books and records, and again, that power exists so a director can discharge their duties and rights as a director to do all things in the company's interest. Now, they can't have those particular documents because they want to sell it or something to someone, or give it to the media because they think it might be interesting. Obviously, that is an improper purpose, and that would be harming the company. And that's just a very extreme example. But that's sort of, that would be an improper purpose. If you're not using it to discharge your duties as a director for the interest of the company, then why do you need it? And so the director might have to say to the court that, look, I want these books and records just because it is for a particular reason, and then the court will have to decide whether they are satisfied. So not only does the court make an order or give relief to that particular director, saying, okay, here you go, here are the books and records, but Section 198F doesn't allow for the inspection by an agent of the director, because sometimes it would be like, well, director's saying, I actually need my accountant to view it. Or if you're in a legal proceeding, you might say that I need our expert forensic accountants to be able to see these books and records for a particular purpose to do with a legal proceeding. And it might be the case that you need, therefore, an agent being that particular accountant or that expert witness. And that comes under Section 294. And so the court is empowered to allow an agent of the director to either access, inspect, or even make copies of those records. Now, what might happen after that is that, again, the court has a very wide discretion. So it could mean that they actually limit the inspection in and of itself, and they might say, okay, well, you want an agent to view these, but I won't actually let the agent view, these categories of documents, or I won't let them do that. And if they are to inspect those documents, they either can or can't make copies, and they can only inspect them on this date and that date, and then somebody has to be present. And there might be sort of some sort of limitations on how that inspection is to happen, or to what part of the particular document the judge might say, well, this for whatever purpose that it might be for, this piece of the document probably isn't relevant to discharging your duties as a director, however this part is. And so the court has that power to do so. And I should say that in Section 198F and 290, if you were to be making an application, it would be the court's power under Section 1303 or 1303 of the Corporations Act, and that allows the court to compel the production of those particular documents. So hopefully that is a case that people don't end up seeing themselves in, but it's not. You wouldn't want to be a sort of like a director or somebody else who prevents that inspection to say, well, that's all done, I can just stand there in the way, and then they won't be able to see the documents. Directors do have rights to be able to go to the court and ask the court to compel production or give right of access to inspect those books and records. Now, that is to say that essentially that when that applicant might rock up at the court is going to automatically assume, unless further information is revealed, that director absolutely has a right of access. Why wouldn't they? That is a common law right, and is a right under the Corporations Act. But not only as a director, but also former directors from a period of up to 7 years can also inspect books and records of the company, but again, not for an improper purpose. So that's something really important to think about and how we remember our rights. So it's yeah, it's not as simple as sort of standing in the way as saying that, well, look, you might be a director, but who cares? I can just stand in the way.
Why would someone withhold access from a director?
Well, it's a really good question, and I think it's because what's in those documents that they may not want them to see. There could be a transaction that they don't know about. It could be something nefarious, or it could be someone sort of just saying, look, I'm here to protect the company. I don't want anything bad to happen to the company, and I feel that you have an ulterior motive by looking at these documents. Either you're trying to do it for the purpose to assess what the company's worth, you're trying to sell your shareholding in the business, and therefore you're trying to go out and get a third-party purchaser that may not be in the company's interests, and therefore you might engage in shareholder oppression. There could be a number of reasons why they might say, look, I don't really want to give it to you. I can't have you see this for whatever reason that might be. But unless there is a genuine way to show that that inspection is for an ulterior purpose, I'm sorry, but directors do have a right of access. And again, I mean, if we're so headstrong about not allowing, then the court's process needs to play out. And when it's all before the court and the judge will exercise their discretion, allowing whether there is a improper purpose or not, and whether those documents need to be inspected so that director can discharge their duties as a director for the benefit of the company. And so that is essentially a snapshot of directors' right of access. So I think we need to be aware of that the law is pretty strong, and it is almost an unfettered right to do so. And if you ever need any advice about that, whether you're a director or of a company requiring access, or sitting there thinking, I would actually like to prevent that access, Ancient Group Legal are always here to lend an ear and listen and advise accordingly, and let you know what your rights are or what the other person's rights are limited to, which under this law is not much. So that's always important. So be some thoughts to take away.
To give access, do you have to go through the court?
If you're going to the board and saying, look, can you give my agent access to do X and Y, and they say, sure, no worries, that's fine. But if you're going to the court and you don't actually want to inspect, and you're a director and you don't actually want to inspect the documents for yourself, and it actually is for your agent to look at, you do need to seek that relief under the Corporations Act, and that is under Section 290, to say that, look, you essentially say, look, by the way, just so you know, Your Honour, I'm not actually the one doing the inspection here. For the purpose that it's for, I actually need my agent to be able the one to inspect or make copies. And you have to seek that relief, otherwise your agent won't be able to if there is an order.
Any other notes? That seemed to cover it pretty well.
Yeah, look, I could get into all of my favourite cases about this that I've been reading for a long while, but I think I'll probably leave it there. But I know that one day I'll probably get to maybe one day I'll get bored of work. That won't happen. But if I ever do, I'd be happy to sort of write more of a bit of a piece on it, which actually refers to particular sections of these cases to give more of a deeper insight.
Thank you for listening to this episode of Plant Grow Reap. Subscribe wherever you get your podcasts, and we'll be back again in 2 weeks with another episode.